afternoon, everyone. My name is Michelle, and I will be moderating today's discussion for the Government of Alberta's FASD Cross-Ministry Committee. It is my pleasure to welcome you to today's FASD webcast. It's part of a monthly series of webcasts on issues relating to fetal alcohol spectrum disorder. This webcast is part of FASD Cross-Ministry Committee's initiative and 10-year FASD strategy to provide accessible educational sessions that cover a broad range of topics that are accessible to all Albertans. For more information about this series, check your emails for our regular updates, or you can go to csslearningseries.ca. You can also follow us on Twitter. Our handle is @AlbertaCSS. We have an exciting discussion lined up today where we hope to address some of the major questions we have heard over the last year around persons with FASD and navigating the legal system. To help us dive into these topics, we've brought in 3 panelists with a wealth of knowledge on both the defense and prosecution side of this complex topic. With the help of our panelists, we're going to take time to explore the special needs of a person with an FASD who is navigating the courts and the legal systems, and the creative ways our panelists have overcome them or believe they can be surmounted. And as always, you'll be able to pose your questions to our panelists via our live chat, which is just below your video window. We will address as many of these questions as we can during the question and answer period at the end of this panel. So let us start off today's session with some introductions. Kathy Lane Goodfellow, QC, has been a lawyer for 30 years and has spent much of that time advocating for young people in conflict with the criminal law. She provides litigation support for nonprofit addiction treatment centers for youth in Calgary, and as well volunteering for CFAN. Nicole Murphy, Mitzi is a registered social worker for Alberta's Youth Criminal Defense Office. In addition, since 2008, she has developed and co-facilitates the FASD Justice Support Project for youth in Calgary. Neil Weiberg has been Crown Prosecutor or Chief Crown Prosecutor since 1984 and was appointed Queen's Counsel in 2006. He was a member of the Lakeland Adult FASD Multidisciplinary Diagnostic Team and is currently on the Canadian FASD Diagnostic and Training Center team with Drs. Val and Dawn Massey. Nicole Murphy is our online moderator. She'll pose your web chat questions to our guests. Today's session is also being recorded, and the video will be posted on the Alberta FASD webpage after this live recording. Well, first of all, thank you all for being here today. We appreciate you taking the time to explain this complex topic. I'd like to give an opportunity to each one of you to explain a little bit about what you do and introduce yourselves to our audience. So I'd like to begin with Kathy. First of all, what piqued your interest in youth with FASD with regards to the legal system?
Well, I can tell you that I have practiced in the area of youth criminal justice since 1984, which seems like a really long time now. But I have the benefit of working for a long time with an office, with the Youth Criminal Defense Office in Calgary, and of course there's one here in Edmonton, where there's continuous advocacy for a group of young people. And the benefit of that is that you start to see a pattern of behavior, and you start noticing it, and you have a very educated group of provincial court judges who are interested in brain issues and brain injuries. And so we fell into a path of learning about the impact of FASD on the behavior of young people who come into criminal court. And our role as advocates is not just as criminal defense lawyers, but to look at the whole child and the context of their lives in order to provide some multidisciplinary approach to their offending behavior, to stop their offending behavior. So it became a real area of interest for all of us, I think, in this office.
How has your experience influenced your views on persons with an FASD with regards to the legal system?
Well, how is it influenced? So my experiences have told me that we spend a lot of time on the challenges that young people have had and not a lot of time on talents. And so what has it told me over the years is that we need to change the language of criminal law to be one that's geared more towards managing individuals in the community and offer resources. So what it's told me over the years is that we make inroads when we provide wraparound service for individuals. It's been a long learning process, and it's really infused my practice in how I communicate with individuals, how I communicate their disorder to the court, to Crown, how I interact with stakeholders. It's become a collaborative process, especially in the youth justice system. I wouldn't say that necessarily for the adult system. I have hopes for that, but that's been my experience.
How about you, Nicole? Tell us a little bit about you and the information that you can tell us about FASD and the legal system.
I work at the Legal Aid Alberta's Youth Criminal Defence Office, and I'm a social worker there. So we're a multidisciplinary law office that work with young people who are charged with an offence under a criminal offence, or really any tickets, anything. My role is to deal with the systemic issues that have led to their criminal behavior. So for me, FASD is a huge barrier when working with a young person involved in the criminal justice system. So we try to do our best to be as educated as we can, and to try and bridge the gap between young people who are coming into conflict with the law, so they don't end up in jail, so we can talk about what other services we can provide for them.
And tell us about the FASD Justice Support Project for Youth in Calgary and your role as a co-facilitator.
Yeah, so under Section 19 of the Youth Criminal Justice Act, the court can convene or cause a conference to be convened. And in Edmonton, they started this project, I believe, a couple years before we did in Calgary, and it was working well. And so we started it in Calgary to address really the needs of young people who have this diagnosis. So my role is really to bring together, it's a partnership between Alberta Justice and Solicitor General, Young Offender Branch, and we co-facilitate these meetings to hopefully address the gaps in services for these kids. So really to create a plan for the court moving forward, so the court will be satisfied that these kids will be safe in the community, and that they'll have the services that they need to be successful.
Neil, tell us about your background.
I've been a Crown Prosecutor since 1984, or a Chief Crown Prosecutor. Around the year 2000, I was Chief Crown Prosecutor in St. Paul, and Lakeland Diagnostic Team started an adult team. They'd had a youth team for a couple of years, and it was the first adult team that was started in Canada. And their management were of the view that it would be good to have a lawyer on the team, because so many of the adults had legal issues, not necessarily as accused persons, but some of them would be witnesses, but they all seemed to have some kind of legal issue. So I would attend the clinic with the rest of the multidisciplinary team. We would come with a diagnosis, and then would be the treatment plan. So I was more involved in the treatment plan because that's where the legal issues would come to bear, and that would be part of their treatment plan, would be to take care of those legal issues.
How important do you think it is from your side to know about FASD and getting it diagnosed, knowing about those diagnoses?
It makes all the difference in the world. Afterwards, after I received my FASD training and was at a couple clinics, I just thought to myself, look at these cases that I've dealt with before where I know now someone at FASD, but I didn't realize it before. And just a quick example, when I was in Fort McMurray, a young woman was sentenced to a crime, and she was ordered to perform 50 hours of community service work. And she was ordered to perform them at the Fort McMurray Public Library. And that's not a bad gig. If you have to do community hours, the public library is not a bad spot. So she was due in court on Friday. She'd had several months to do it. She came on the Thursday and said, I'm here to do my 50 hours of community service work. And the librarian said, well, you can't do 50 hours now. You can do what you want and we'll give you credit for it, but we can't give you credit for 50 hours right now in less than a day. And so she just left. She didn't do any hours at all because she was frustrated. And when it came back to the judge, he heard she did 0 hours, showed up the day before, wanted credit for 50, didn't do any. And of course, he was quite angry and thought this was a willful breach. I now know this is classic. She had FASD. And if we'd been able to identify that to the court, I think there would have been a better outcome.
I can imagine. Would you ladies agree?
Oh, totally. Absolutely. That's a story that similar stories happen every single day. I don't know if you want more stories.
Yeah,
but,
yeah. Why don't you have an example that you've experienced?
Well, and typically, I mean, when we changed from the Young Offenders Act to the Youth Criminal Justice Act, what is it, 2003, so some number of years ago, one of the desired outcomes was to lessen administrative type offenses like breaches. And so we started to identify these young people who for whatever reason were frustrated in their attempts. So I've had, one client that comes to mind is, and this is, a rather sad story, but she would, reach out for help because she needed money and she was struggling. And when we would say, well, I can't just give you money, then I would get a text saying, well, I've got money and I need some addiction treatment. Well, I can set you up with an appointment. Can you get to that appointment? I can't get to that appointment, but I did go to the store and buy some crayons so that I can sit in a coffee shop and draw. So you don't know how to deal with those kinds of fact situations, but that's just an example of the thought process for some of these kids. But Nicole will have lots of examples where young people don't pay their C-train fines. They're homeless, they are at risk in the community, they struggle with staying where they're supposed to live if they're in Child and Family Services protection, and they take the C-train. They can't keep their bus pass because they lose it, they sell it, they trade it for something else, and they get tickets. The ticket will say come and pay or appear on such and such a date. They lose the ticket, they forget about it, and then there's a warrant. And so a young person will get picked up by the police on a warrant for not paying $1.25.
Nicole, it sounds like it can start with something quite little, really,
insignificant,
and then just...
Well, you see that a lot on court orders too, right? Like especially when it comes to time, to curfew. So, your curfew is, from 9 p.m. to 7 a.m. you have to be in the house. Well, someone who struggles with time management, that's really confusing. And so, and then it reaches 9 o'clock and they're like, well, I'm already late, so I might as well just keep on going anyway. So we developed this plain language, which I think you're going to be talking about. But one of the conditions in a plain language context is to say, be home by this time, as opposed to be in home, sleeping, in your bed, be in your bed, in your place, wherever you're living by 8:30 or whatever the time is. So that way they know, like, okay, that's the trigger, right? I need to be home by this time, as opposed to my curfew is 9 o'clock. So we find that changing language and just being less rigid with conditions can be very helpful for administrative breaches and that sort of stuff, yeah.
Kathy, back to you. What other kind of strategies would you suggest? The plain language, that seems like actually quite a simple fix, right? It's just restating something in a different way that they can understand.
Yeah.
What's another strategy?
Well, can I go on a little bit about
of course.
let me tell you a little bit about the plain language. So one of the projects that we undertook at the Youth Criminal Defense Office is we gathered a bunch of different stakeholder groups, including Solicitor General, the Crown, people from corrections, to talk about conditions. Now, it's not as easy fix because the criminal code requires certain conditions to be in forms of release or in probation orders, but we actually hired an expert to create a plain language version of the statutory conditions in the criminal code and in the Youth Criminal Justice Act, so that they could be used in court. It was a little bit of a process, but we did end up with conditions like, rather than saying you must be home between this hour and this hour, which is all about staying out of trouble and being out of a risky situation. It's be in your bed, which is easier for this client group to understand. Or sometimes it was reduced to pictorials. So you would have a condition, don't drink, don't drink. And so I know that other jurisdictions would have pictures of a drink, like a martini glass with a big X through it. So because a lot of our clientele can't understand the legal language. So they would be shown this picture, do not drink. And some, because they're such concrete drinkers, might interpret that actually to mean don't drink martinis. But in any event, it's one way for the internalization of conditions. So we've struggled with that because the plain language has not been universally accepted, and it's sort of an ongoing process too, because each and every judge considers their courtroom their own courtroom, and they will use whatever they will manage it the way they want to manage it, right? But we found that plain language is an important feature of communicating with this client group.
Neil, I want to get your side of this too, and how big a difference does it make for you if you have an FASD diagnosis and things like strategies are implemented?
Makes a big, big difference. First of all, I know how willful the breach is or how willful the crime is. If I know the person has FASD, I know that, and we use the phrase external brain, that's someone that helps the person with FASD around in the community. If there's not an external brain, there's almost no chance that they can comply with a probation order. Mm-hmm. The probation order will show up so often to see your probation officer, pay restitution, go to anger management counseling, go to this type of counseling, and say pay restitution. There's just so many terms. And someone with the deficit in executive functioning, like someone with FASD, just can't put all of that together. Mm-hmm. So it's very, very important to use the external brain. So I encourage our probation officers, don't just speak to the accused person, speak to a parent, speak to a friend, and then that person will be able to get them to the appointments. Because if the person is left to their own devices, the person under the order, they won't. So I know they're an adult, but still go to other sources and have that person help them bring them to their appointments. So if I know that, that's a big, big help.
Sure, and if they have a responsible adult with them who can guide them through the process, that's just going to be a benefit to everyone.
And actually, some of the diagnostic teams have a support worker to follow up on the treatment plan, and that can be used in conjunction with the probation order. Mm-hmm. And that's because a lot of these treatment plans were prepared by the multi-diagnostic team, and all of a sudden the person is on their own and doesn't understand, doesn't follow any of those treatment plans that were worked out for them. So I know Lakeland, for example, hired a position just to make sure each of the people with those orders, those treatment plans, would comply with those treatment plans. Again, that's not legal in the sense that they were subject to sanctions, but the same thing could be if they were on probation, that same person can help them go to their appointments.
How important is it, and I'm going to begin with you, Neil, just to have everyone or more people within the legal system educated about FASD, diagnosing it, understanding it?
It makes a big difference, and from all reports I get, as soon as a judge hears about it or Crown hears about it, Defense Counsel, everyone tries their best in order to get that new information and take advantage of it. But just getting that first bit of knowledge is the difficult part, and so that's where it's essential that that kind of knowledge be given to judges, given to defense lawyers. One other example is that people with FASD have very high speaking abilities. It's actually higher than normal. So if they're an 18-year-old, their speaking ability is that of a 20-year-old. So they really speak really well, but on the other hand, their comprehension is like that of a 6-year-old. Mm-hmm. So if you're a judge, you see someone speaking for 1 or 2 minutes at a very high level, that builds up very high expectations. And if you don't know they have FASD, you don't understand that their comprehension level is that of a 6-year-old.
Wow, that's interesting. That makes things all the more confusing.
And the difficulty in the legal system is just so little time. The dockets are very long, so duty counsel and the judge has very minimal exposure to these people. And if the person speaks really, really well, that's the impression that's created.
Well, I totally agree with you, and knowing that what it actually means when it comes down to like looking at the person. So I think a lot of people have a general understanding that there's this brain injury thing. It's called you get it when you're drinking, and the fetus gets it, but they don't really understand what that translates to in like a courtroom environment. So like you say, the chronological age difference. So, or, you know, light and sound and how that can be affecting a young person or anybody sitting there with this diagnosis who have sensory regulation issues, or time, being late for court. You know, they're not being disrespectful, it's because they actually have issues with time, or giggling a lot, or, you know, those sorts of things. It's really important, I feel, to understand the diagnosis. You can put into context the person's behavior, especially the bench, so the judge knows that none of this is willful. It really is because of a brain injury.
Kathy, I want to bring up specifically what you said about each judge having his or her own court chamber and how they kind of run their operation. Why is it so important that judges get on the same page and learn about this and start to understand what's going on?
Well, I will say that the provincial court bench in Calgary, and actually in Edmonton too, sit both in family court and in youth criminal justice court. So they see these children who are in the protection system, or who they see them actually go from one system to the next. So they're actually quite educated. And I think one of the judges spearheaded educational process for provincial court judges. So I would like to say that the Calgary Provincial Court Bench on the youth side are very educated, but that doesn't necessarily translate to the adult side, because I want to say the mandated outcomes for youth justice are different than the adult justice. But so it's somehow not good enough to me to be educated in what the diagnosis is without knowing what its impact is in the different aspects of the justice process, all the way from arrest through the bail hearing process, through the appearances in court. And so the court needs to know not just about the diagnosis might be present, but how that impacts that young person or that adult person through the system. Now, education should be evolving. We should be constantly re-educating ourselves about new developments, because every single year there's a wonderful conference in Vancouver. It's an international FASD conference. There's always new developments in terms of determining prevalence, or in the diagnosis, or in prevention. There's always new developments, but we stop at, okay, we know about it. Now 10 years go by. So to me, judges need to be educated, but they need to continue in that process all the time. But we talked a little bit earlier, Michelle, about how the defense lawyers are really the first people who have the opportunity to interact with the accused, adult or young person. And so for me, it's even more important for that defense counsel to be educated, to identify the red flags, and so that when something doesn't smell right, look right, if it walks like a duck and talks like a duck, it's probably a duck, then there's that person is going to fall through the system all the way along. And so, you know, my big push would be for justice stakeholder groups to all be educated, and to continue that education, and to continue the conversation with all of the helping groups in the community. And I know that's going on to some degree, but education in and of itself is not enough.
Neil, do you agree with that?
Oh, I agree with that. And one of the difficulties defense counsel have is a lot of people that suspect they're FASD don't want their defense lawyer to know that. And there's issues about they feel guilty, or the mother feels guilty about drinking. And so unlike someone with a broken leg that'll come forward and say, I have a broken leg, I can't do these things, a lot of people with FASD, when we were in clinic, didn't want the clinic in their hometown. Our Lakeland clinic traveled around, and we'd have people that would live in Bonnyville, for instance, say, I want to go to a clinic in Lac La Biche, because they didn't want people seeing them walking into the local clinic. Yep. And a lot of them said to us, we don't want other people to know this diagnosis. And so the difficulty is the accused person doesn't come in advertising the fact he suspects he has FASD. The defense lawyer really has to find that out on their own.
Nicole, sorry, can I just butt in for half a second? Nicole expected this. Is that, I don't know about you, Neil, but when I was in law school, we did not learn these communication skills with clients or with their mothers. So if we're dealing with a young person and we suspect that they might have this disorder, we are not trained on how to speak to the mom in the short time that we have when we're meeting those kids for the very first time. Can you just imagine it? Me trying to ask you if you drank while you were pregnant with this child that's before the court.
Yeah, it's inappropriate.
Yeah. Yeah, but it's also part of an investigation that you do, right? And
what do you think needs to be done then, Nicole, if you can't come right out and say that?
Oh yeah, I would never ask a mom. Yeah, yeah.
What can you do?
I think I go in there assuming everybody is, like honestly, or everyone has a diagnosis of some sort, because I'm already working with a vulnerable group, which are children, plus they're already in a very vulnerable situation being in a court of law, plus like they often don't have parental support and whatnot, and then, you know, I just assume, I talk to them all the same, and I've been trying over the years to change my practice so that it's uniform, because again, I don't know, I can't, like sometimes I only get 5 minutes. It's very triage based, you know, when I first meet kids in court, and so I don't know either. Yeah,
must be quite overwhelming just with the possibilities.
Right, yeah, so or just overwhelming, I guess.
All right, I want to move on to the future and hopefully talking about some ideas to improve the situation. So Nicole, I want to start with you. I'd like more detail on the FASD Justice Support Project and the goal of that project.
So, okay, so the goal really is to have kids get out of jail with this diagnosis so they'll be safe in the community. And I don't mean like it's a get out of jail free card, but really by conferencing, it is a court-imposed case conference for these young people who don't necessarily have supports in their life. So the co-facilitator through Alberta Justice and I are tasked with trying to find resources that will hopefully meet the young person's needs and the recommendations as outlined in their assessments. So the goal really is to make sure that these kids are supported in the community, understand their diagnosis, and their supports understand their diagnosis, because the multidisciplinary diagnostic team, Medagene in Calgary, attends these conferences to speak to what the strengths and the challenges are for each specific young person. So whoever attends the conference will know this is how we need to change our practice when working with this kid. And to give them more supports in the community so that hopefully we don't see them again.
What kind of results have you seen?
So interestingly, so there was a report that was done in 2015, and people can email me if they'd like a copy of it, but it was a very small sample of young people, and we just wanted to see, to test the effectiveness of the project to see if it was working. And most of it, actually all the information came from Calgary, but they found that the violent recidivism had lessened. There was still some administrative justice breaches, but not as many. And they recommended that we implement it all over the place, that people should be doing this, with some other recommendations, obviously, just to fine-tune it. But it was really, really positive, and so we're really excited about that, to keep doing the work, right? Yeah.
All right, so that report, they can email you. I'm going to give you the email. I'm going to give the audience your email address right now, and then we'll talk about that again at the question and answer period.
Sure.
It's NMIZZI at ycdo.ca.
Yes.
Correct?
Yes.
All right, that will be good. Neil, I just want to talk to you about the kind of progress that you've seen being made in the courtroom and outside the courtroom.
The education has really worked well. In the provincial court, most judges that I appear in front of are familiar with FASD, and when they hear that's an issue, they take it very seriously, and that affects their judgments at the end of the day. It's just so important to know that. One of the red flags we often see is someone with one innocuous offense and then multi-breaches afterwards. So a person gets a shoplifting and they might be ordered to do some community service hours. They don't do the community service hours, so they're charged with breach of probation. They again don't do the community service hours, so they get another breach. And often you'll see someone with one shoplifting and 7 or 8 breaches of probation, just because they don't have the ability to follow through with these obligations because of the deficit in their executive functioning. And think of all the court time, think of all the time the probation officer is hounding this person. Just look at all that to get one shoplifting and 8 breaches. So if people knew right off the bat this was someone with FASD, the result and the saved labor would be great.
What if legal professionals were able to have more time initially? Would it save time down the line,
it
money,
would be, yeah,
energy?
it would be very helpful. I'm sure as defense counsel, if you were a duty counsel, if the dockets were a lot smaller, if we had 20 or 30 in a docket instead of 100, you'd be able to spend a lot more time with the client. And similarly, when the judge wants to speak to an accused to get a sense of them, if he knew there was an hour left of docket as opposed to 8 or 9 hours left, that would give everybody more time. It'd be very beneficial.
What else do you think needs to be done to move this forward?
I think just everybody knowing about the FASD is the most important thing, and the opportunity for people to have the time in order to do that, as well to have more studies done on individuals, to have more diagnosis done. And sometimes even if it's not a full FASD diagnosis, the neuropsychological testing part is the most important. And the more of those you have before a court, either an FASD diagnosis or neuropsychological testing, would be very, very helpful.
Kathy, where do you see the positive side of this?
I too see the positive in the education, and that education is readily available. The networks that the cross-ministry committee have created, I think likely each have an educational component that's available to people. And I know in Calgary that defense lawyers have taken up on that. So education, I think, it's come a long way. But what my concern is, and getting to the more time to speak to the individual, in Calgary the youth dockets are smaller. There is an opportunity, and there's a youth worker that goes to court every day to speak to those, to speak to young people that duty counsel will identify as, there's something going on here, there's something not quite right. I want you to do a little bit more digging while I'm in court dealing with the next young person. In Edmonton, the dockets here for youth are a lot larger, but it's still, there's still a youth worker. There is still an opportunity for lawyers to say, I want you, Nicole, substitute, to spend that extra time with an individual, because their job is to look for resources too. It's a very different setup than in the adult system. So if moving forward, I would say there needs to be a person in that role in the adult system that can spend that extra time. Lawyers who have a minute or a minute and a half, 2 minutes in order to speak to these individuals may be able to identify some red flags during that conversation and say, I want you to have this word with this worker. But what I'm concerned about is that we've gone from identifying the disorder, but my worry is that the courts sometimes still look at FASD as an aggravating feature of the offense and not a mitigating feature. Because people with the disorder often look very presentable. They don't have the facial features that sometimes are associated with the disorder. They speak well. Their behavior looks really willful and aggravating, and they're often people who just irk you because nothing seems to be getting through to them. So my worry is that because we don't come from a place of, we can manage these individuals if we have correct resources. If we have that mindset, we think of it as mitigating feature. If we don't have that mindset, we still think about it as an aggravating feature. And if that's the case, then we're going to be spending hundreds of thousands of dollars of warehousing these individuals in the community or in custody. So there needs to be more education for the community on how this disorder interacts in the justice system. And I'd like to share one story. Can I share one story?
Of course, yes.
Which a young woman who I met last week said that she was going to watch this presentation, and she works in the field, and she said she went to court with an adult that she supports through one of the agencies in Calgary. And he had done something, and he must have had a significant enough record to merit being in jail for a month while this was all happening, the enter of the plea and the get to the point of sentencing. And the judge and the Crown said, well, this individual should either get more jail or should be released on probation conditions. And because of the remand time, that the support worker stood up and said, well, conditions on a probation order will probably not be met because of this individual's diagnosis, and I'm going to ask for no sentence at all. So good, so then this individual was released, just being consequenced by the fact that he had been in custody for a month, which is not rehabilitative, which didn't provide him any resources, which was, 3 meals and a snack pretty much every day. So if you're a member of the public, how are you feeling about that individual being released with little consequence? So there needs to be a bringing together of the information about the impact of the disorder on individuals who commit largely impulsive offenses, so that society can have more confidence in the justice professionals and the work that they're doing. And Neil can speak to that very well because of his role as Crown, and of course Nicole, because she's in court every day.
Do you want to add something to that,
Yes.
Neil?
Obviously, as a Crown, your main issue is public safety, and there are, unfortunately, cases where someone with FASD commits a terrific violent offense. I had a homicide a few years ago, someone with FASD that was robbing homeless people and stabbing them, and then someone came to this lady's assistance and then he stabbed and killed that person. He'd had a bad record of violence. He did have FASD. He was highly intoxicated, so it was a manslaughter, but the main thing is to protect the public in a case like that. So regardless of whether or not he has FASD, public protection on those serious offenses are very important. I had another fellow, again, he had FASD, but traveling around on a bike on a McDonald's parking lot, stabbing people at will, and stabbed 5 or 6 people. Now, you can suspect FASD because there were 20 eyewitnesses, there were video cameras. There's just no way of getting away on something like that. But again, the public needs protection for those kind of offenses. But for the bulk of the offenses we see, well over 95%, the person isn't a danger to the public, it's a nuisance to the public. And in that particular, when you know that, it saves a lot of public resources. And Kathy's story about the person not getting out of jail, that's because the person probably had 1 shoplifting and 8 breaches, like I described earlier. So when you have a bail hearing, the judge is saying, oh, you've breached 8 times before, why should I give you another chance? And that makes sense. But the difficulty is the person shouldn't have that record to begin with.
Nicole, do you have any stories of things happening well and in the right direction?
Yeah, I think, I think there is movement. There is definitely a recognition now. I can only speak to my experience in Calgary, the bench and the bar, like everyone knows about FASD, I feel. It's now about how to take it to the next level and change our practice so that we're doing what the research says we should be doing, right? But I do feel that people have a better understanding than they did before, and take the recommendations from these reports and take them into consideration for sentencing, and I think, and for bail, and I think that's great. And if we can, again, put that to the next level of what else can we do to actually change what's happening inside of that courtroom, we'll be golden, right? But yeah, I think there is a lot more understanding than there ever was before.
How do we get to that next level?
Yeah.
Designated courts for
yes,
individuals
that would be
with...
amazing. I know they do that in Saskatchewan, like the mental health and FASD court. That would be amazing.
So a specific court.
Yes, I think
kind
so.
of
And just, little things like a lot of the times the Crown, no offense, will say, well, we should put more conditions on him and that way he'll be safer and he'll be better and he'll be more rehabilitated. But we all know the more conditions, the more likely they are to breach. So that doesn't often work with people with this, or doesn't work with people with this diagnosis. It's just they keep ending up back in the system with all these breaches. So if we lessen maybe the amount of conditions as opposed to increase them, they'll be more successful, and that's kind of what we're looking for here. So stuff like that, yeah.
Do you agree with that, Neil?
I agree with that. And the other thing is sometimes you don't have to lay the breach. That if you as a probation officer know the person has FASD, I would welcome the probation officer phoning me and saying, look, Neil, in this particular case, I don't really think it's willful, that didn't harm the public in any way. Do we really have to breach them? And I'd say no, it's not in the public interest to go ahead and lay that charge.
Hey.
Kathy, do you agree with that too?
Oh, yes. I mean, half of our job was always negotiating with the Crown, and if they're for the most part quite reasonable, and if you give a good second plan or plan B, then they're gonna go with it, because they see the disorder is not, they don't see accumulating a record as being a helpful thing for the accused. So I do see those kinds of things happening. I will say that, Alberta, we really are leaders in Canada for the work that's being done in the justice system with individuals with FASD. We're known worldwide. The Youth Criminal Defence Office is one of a kind in Canada. It's the only one that I know of that has defense lawyers and social workers and youth workers working with young people and creating a multidisciplinary attempt to create a multidisciplinary wraparound program for the young person so they don't reoffend.
I think Alberta's unique as well, having them all around the province. That other provinces might have it in Vancouver and Victoria, but Alberta has it completely around the province.
Which I think brings me back to your point that you made earlier about the stigma associated with it, and so they can go. I wanted to ask you, back at that point, how do we overcome the stigma for both the mother and then the victim?
Right off the bat is not to blame. That it's not a blame situation. It's happened, but to start to blame and judge isn't appropriate.
The international conference this year in Vancouver, there was an entire day dedicated to stigma, and it's about how we phrase things, what language we use when we're talking to women who are pregnant, who are talking to women who've had children who have FASD. Maybe we assume that they have an addiction, but I live in a city where the Calgary Stampede, where there are lots of ingestion of alcohol over 10 days, and these could be anywhere from lower to high class individuals. So it's the education about prevention too, which I think is really important. But anyway, I kind of was losing my track of thought. You were going to say something?
No.
Oh, okay.
Yeah.
But Nicole, do you agree with that? Talking about even just looking way back there where it all starts. How about the importance of education? Because we do hear about it. We do know. I mean, when I was preparing to have children, I knew very well, and I didn't drink at all, but I'm a very disciplined person. How do we get that message out to women?
Oh, someone said once that you should include a pack of condoms with every beer case or something, like they should start doing that, which is just a fun, anyway, but yeah, I have zero, I think they're doing a really good job of getting the mess. I think a lot of women know. I think it's like not to drink when they're pregnant. I just think a lot of women don't know they're pregnant when they're drinking, and that's a big hurdle for a lot of women.
I think there's a lot of social pressure on women. I think there's peer pressure. Oh, come on out. One glass of wine isn't going to hurt you. There's social situations. There's lifestyle situations. We lay blame on the mom, but it's the whole family unit that needs to take responsibility. So at this conference in Vancouver, there was an organization from Western Australia who came with a video, and I thought it was one of the most powerful videos I'd seen regarding the issue of prevention. And it was a man who talked about how he had given up drinking throughout the pregnancy of his wife because he wanted her to be supported and he wanted to have a healthy child. And so I thought, what a powerful message. Use of alcohol is so insidious in our world and in our social,
glamorized a lot.
And glamorized, but it's not just stigmatizing the woman; it's stigmatizing the individual with the disorder. Because I think that people who aren't educated or who aren't who don't know about what the resources are available, don't know or don't think that individuals with FASD have talents, who may have challenges but have abilities. And so we lose track of that when we see that it's a brain injury and it's lifelong. It's lifelong.
It's important that we move beyond that and see what they have to offer, as opposed to what, you know, mistakes have been made and the challenges that they face, but how to overcome it in a positive way. Okay, I'm sure we have lots of questions from our audience, so let's turn it over to Nicole, our moderator.
What are some red flags that justice professionals should look for?
Oh, I'd be happy to answer that question.
Go ahead,
Since I
Kathy.
prepared for that question. I will say that over the years, lots of organizations have created acronyms to help you look at or identify red flags. And that acronym is called ALARMS. And so A stands for adaptation. So how that shows up is you might have an individual who has poor hygiene, poor social boundary issues, poor social skills, judgment issues, difficulty with transitioning from one thing to the next. Language is the next, which is most individuals with FASD have lots of words, lots of vocabulary, but very little comprehension, and may not understand those words that are not concrete, such as the word maybe. Can I go out tonight? Well, maybe. It's not a concept that's going to be understood by individuals with the diagnosis necessarily. It's abstract thinking. The A is attention. Many individuals with FASD have attention deficit hyperactivity disorder, so they are easily distracted, extremely impulsive, so that will show up in their offending behavior. R stands for reasoning. Don't learn from consequences. That's the multiple breaches that can't seem to learn that you shouldn't hang out with Joe Smith because they're always in trouble, and not understanding that picking up a car behind a 7-Eleven at 3 o'clock in the morning and only paying $20 might not be a good idea. Seems like a good idea at the time. M stands for memory. Typically, memory is impacted by this disorder, so that you will learn something today and you will not remember that the next day, which really impacts court appearances, court requirements such as probation orders or conditions or release conditions. The last is S, so alarms. S is sensory processing. So many of our clients have issues with touch, taste, sound, any sensory. They're overstimulated, so being in a big courtroom with lights really affects them. You might find a person being stopped by a security officer in a mall for stealing something from Claire's. Sorry, I had to add that. And then act out, and act out. But you know what I mean, like a very small item. But when they're put their hands on by the police or security officer, they react. They hit back. They take it as an attack, and then they get charged with resisting or assaulting a peace officer. So it's just that odd kind of behavior. So alarms, that's what that stands for. Those are really the basic red flags.
Neil, do you have anything to add to that?
Yes, there are just certain cases where it just doesn't make sense. A classic example would be a group of youths breaking into a confectionery to steal pop and chips. The alarm goes off, everybody runs away, but one person's still standing there, sort of in a fog. That person probably has FASD.
Eating the chips.
Yes, but waiting for the police to come, not running away with everybody else. And unfortunately, they're seen as dupes by other individuals. They have social issues, so they often don't have friends, so they're befriended by bad people that take advantage of them. And the person with FASD is the one that'll volunteer to keep friends, to be first one to go into the confectionery. And if it has an alarm, everyone runs away and they're still there eating chips.
Yeah, so they're vulnerable and then they become the fall guy.
Well, and that's when the difference between chronological age and actual brain-based age are really important. Yeah. Sorry.
All right, Nicole?
How and where can an individual be assessed for FASD?
Nicole, can you answer that?
Yeah, in Calgary, there is a multidisciplinary team called Medagene where they can be assessed. Renfrew used to do, I think they still do, Renfrew Services still does FASD assessments for little kids, but adults would have to go through either Medagene or I know the hospital have different diagnostic clinics, but they're not as recognized as Medagene is. Medagene is really, I keep saying that, but they're the go-to place in Calgary. In Edmonton, Glenrose, Dr. Frenzel I know does FASD assessments, and you could probably speak more. Lakeland does them.
Lakeland,
yeah,
Cold Lake,
yeah.
Dr. Don and Val Massey
yeah.
at the Canadian Centre does them. If you contact the FASD Alberta team, the FASD Alberta, there's one diagnostic team in each area, and they'd be able to tell you the closest one to your area.
That's a good idea.
So that's the committee with all the various government departments that cooperate with FASD, and they would be familiar with where in Cold Lake, where in Fort McMurray, where in Medicine Hat you'd be able to get a diagnosis.
And then again, you could go to the one you feel comfortable going to as well.
Yes.
Right, so there are a lot of options out there.
Certain ones like Lakeland was traveled, and so if the patient, Lakeland would go all the way to Lac La Biche to the east, or to the west I should say, and Bonnyville, Cold Lake to the Saskatchewan border, and St. Paul. And so they would travel to where the patient was to do the clinic. And sometimes if the patient didn't want the clinic in his hometown, he would request a clinic in a different location.
Is it free through that?
No.
No, yeah.
No.
Yeah, you have to pay, yeah.
You have to pay. Usually, like Alberta Education would pay a lot. PDD would often pay for the adult ones. I'm not as familiar for the youth, but I was on the adult team, and various agencies would pay the fee for the diagnosis and treatment plan.
Okay, Nicole?
I believe we did touch on this a bit, but just again, how can a society be protected from a violent offender with FASD?
Neil, you might want to speak to that.
There are various, our Court of Appeal has various offenses that denunciation and deterrence is the prime consideration. And so whether or not a person has FASD, if it's a murder, for instance, if it's a manslaughter, if it's sexual assaults, serious sexual assaults, those have to be, protect the public has to be the first consideration. So if the person has one disability or another, that's dwarfed by the seriousness of the offense. And so on that manslaughter one I talked about, that person got 14 years in jail for that particular manslaughter. There was a youth case in Lethbridge where someone that was under the age of 18 murdered a group home worker, and that person got the maximum sentence they could under the Youth Criminal Justice Act.
Yep.
Actually, they were transferred to adult court and then received the maximum sentence. So on serious offenses, public safety is paramount, and sentencing is done accordingly.
And I'll say that I agree with that approach, but it doesn't stop with the incarceration, and as that individuals with the diagnosis can learn management skills while incarcerated if the proper resources are available to them there, because no sentence lasts forever, and they will be released to the public at some point in time. But public safety issues is important.
How widely available is that in jails?
That is a really great question. So I can tell you my experience in the youth justice system is that they're very live to the issue, and that agencies with that particular knowledge go into the institution to help with the transition planning for children who are going to be leaving that custodial setting. For adults, I don't have any knowledge, although I know that out of Bowden, which is a provincial institute, right?
No, it's federal.
It's federal? Okay.
Yes. It's a minimum security, but federal.
Okay. I know that there is some transitional work going on in Bowden, but universally, I don't think it's in every institution, adult institution.
I think
in
there's
the
one
province.
guy who does it all for
all
the federal,
Yeah, I think you're right.
So there would be a lot of pressure.
Yeah, and that's a huge barrier, in my opinion, or adults leaving institutions, especially with this diagnosis. Like, there's a real lack of understanding and transition planning and time, and there's just a lack of that. So they leave, and unlike kids, where you know, I think it's under the legislation, but with adults, there's no impetus to give them the supports they need to be successful in the community once released. And the resources are just really lacking. And I think the people who are doing it are doing a really great job, but there's just not enough of them.
All right, Nicole?
How does the project work, and is it available for adults?
Oh, the FASD justice, yeah. So the court, it's really defense driven. So the defense lawyer will know that there's an FASD diagnosis, and we'll get these reports back saying, confirming the diagnosis with recommendations, and usually a pre-sentence report that goes with that. The order is made via the judge to our group, and we read through the reports and discover what the recommendations are and who should be at the table based upon what the reports say. We then interview the young person to figure out who they would like around the table, and because the young person doesn't attend the conference. And then we call upon our steering committee, who is a group of higher level management professionals in Calgary who service young people, and ask them if they can provide a service to this kid, and if so, would they send somebody who would then be working with him. So everyone will meet together. It will be facilitated with Medellin there. Medellin will go through all the assessment recommendations, and then we just sit there and talk about the plan for this kid going forward. At the end of the meeting, I'll write a report for the court, who then takes that into consideration. We don't talk about the offense at all. That should be said from the outset. That's not our role. Our role is to only provide services for a young person, and to figure out how to educate those services so that he'll be successful. So the report's written with who's going to do what the plan is, where is he going to live, what's he doing for a day program, yada yada, and then hopefully that helps with the outcome of the sentence at the end.
Well, and that would be important because you're speaking to, when you're talking about looking at the talents and the abilities, as opposed to what's what they've done wrong, why they've done it, moving forward and looking at it from a different point of view.
And I think there's some movement to have a similar type project for adults.
Well, I'm working on it. There's just nothing in the code, so that we're really lucky in that the Youth Criminal Justice Act has Section 19. There's just nothing that exists in the code. There's not even a mechanism by way adults can get reports. Like in youth court, the court will pay, justice will pay for these Medellin assessments to get this FASD diagnosis. That just doesn't exist in adult court. So trying to go through all those hurdles has been a challenge, but I would love to see an adult court, yeah.
So in terms of some progress being made, I know that there's been on 2 separate occasions now attempts to amend the criminal code with private members' bills to add a brain dysfunction or brain disease, can't remember exactly how it was defined, as being a mitigating feature and an ability to make order assessments like they do under the Youth Criminal Justice Act. So they're live, the legislators are live to this, although I think the wording is troubling, which is why it's not been enacted yet. But yeah. What I like about that conversation too is that they talk about the philosophy of diminished moral culpability, which is actually stated in the Youth Criminal Justice Act. So it's a change in the culture and how you look at this this client group. So if you look at them as being having diminished moral capability or diminished moral intent, then you can really focus on what's going to support them in the community. And you change the language from deterrence, denunciation, and rehabilitation to how can we effectively manage them in the community so that the individual can live safely and that society can be safe as well. So,
Nicole?
win-win.
Where can they get a copy of these conditions and a plain language documentation for defense counsel?
They can email me, and I have all of that. I have the history. Kathy and I worked on that together and hired Bukova to do that research, and yeah.
Okay,
and that also, oh sorry, go ahead.
I was just going to say that email address is again NMIZZO at M-I?
M-I-Z-Z-I, sorry.
Oh,
I,
I'm sorry.
That's okay.
At ycdo.ca. And you can also get a copy of that research study as well.
If people are
sorry, I didn't mean to interrupt you, so you go ahead, what you were saying there. Did I interrupt you
no,
and you lost your train of thought?
No, it's totally fine.
Okay.
Yeah,
Do we have another question?
We do. We have a couple more. What training in FASD is available today for the legal community in Alberta?
Well, I know in Calgary, the Calgary Fetal Alcohol Network has a group of, offers a course called FASD 101, and that is free if you contact CFAN, which I don't know the number off the top of my head, but you can Google that and you can and they will tell you when the next course is being offered. You can actually, as a lawyer, I know this sounds really kind of goofy, but David Boulding, who is he was instrumental in providing information about this issue in early days. So he wrote an article called "The 10 Mistakes I've Made with basically FASD clients," and he put together a little video. So if you Google his name, David Boulding,
His whole webpage.
FASD, it's a little video that he's put together on. It talks about alarms. It talks about FASD as a brain injury. He provides other resources. So it's a really good starter.
And it's also amazing to learn from your mistakes, right? People are so afraid of making mistakes, but you can learn so much. And it's great that he's put up, you know, had the courage to put up the mistakes he's made. So because he's learned from it, and he's hoping that others will learn from it.
Exactly.
I think we have time for one more
question?
Yeah.
For sure. Is there any reports or statistics on how many are affected or diagnosed by FASD in our criminal system in Alberta? How does the panel envision sentencing changing to accommodate this?
Well, there's that one study that says 19 times more likely. It's because there's no screening tool that exists right now, it's difficult to know like precisely the amount of people who have this diagnosis or in jail. But I read a study that said 19 times more likely to end up in jail. I don't even know what that would be for the criminal justice system. Do you have that?
Well, the Institute of Health Economics did had a conference in 2013, and the statistic that they talked about was that there are, what was it, between 10 and 25% of prisoners have FASD. So there's a big difference between 10% and 25%. So they are, as far as I know, the federal institutions working on prevalence studies. But it's really difficult without doing a full assessment, I think.
Right. Stony Mountain Penitentiary in Manitoba did a report, and they had 40%. They felt of their inmates had FASD, but it wasn't a full assessment. It was just a pre-assessment that they used.
Well, and it's quite possible that it could vary across the country.
Yes.
And the problem with the red flags and the screening tools is that the assessment process, according to our federal guidelines, is meant to be a multidisciplinary team process. It's not just one individual. So there's that's really an exhaustive assessment. The metagene assessments are 20 pages plus long, which goes into the history all the way from like the social history of the family. So it's a very exhaustive assessment. So when they do the prevalence studies, I really don't know how they're coming up with those numbers, but 40% would not surprise me. Would not surprise me.
An adult assessment took one full day plus another day for the neuropsychological testing. So 2 days minimum to do a diagnosis.
Yeah.
But again, that time up front could just help us so much.
It's very valuable.
Right? Well, thank you all very much. Great information and so helpful for our audience, and hopefully they can help spread the word, because I think it's really important that the general public knows about this as well and shows more compassion and understanding. And you've definitely shed some great light on a lot of issues within FASD and the legal system. So a big thank you to our guests, Nicole, Kathy, and Neil, for sharing their experience and insight with us. And to all of you who have tuned into this session, we are grateful you have spent the hour with us, and we hope that you have found the conversation informative and helpful. As we mentioned in the opening, this webcast is part of the Government of Alberta's Community and Social Services Learning Series. This month is the final month of the season of the series. However, we will be broadcasting a new season starting in September of 2017. The new season will continue to cover topics from fetal alcohol spectrum disorder, like the one you saw today, as well as other topics like the Employment First Initiative, the Alberta Brain Injury Initiative, ABII, and the Office of the Public Guardian and Trustee, also known as OPGT. To get updates and registration information about each of the sessions, please email us at fasd@gov.ab.ca and ask to be added to our mailing list. And as mentioned, today's webcast was recorded, and the video will be posted online along with videos from all the previous webcasts. The video link will be sent out to all registrants in the near future. We encourage you to share this video with anyone you think may be interested. And of course, if you have any feedback about today's webcast, please email us at fasd@gov.ab.ca and let us know. We'd love to hear your ideas. Have a wonderful afternoon, and we hope to see you again in the near future.